If somewhere in the future, you and I are having another conversation on the file I just put you on probation on because you're not doing everything exactly right, but I can see that you've really been trying to take care of your business, then I can give you a little grace. But if you just ignore everything you owe the court and you're having problems, all right, because I don't want to punish you on this case. But if you just go out there and start doing stuff the wrong way and you don't come ask for help, then you kind of tie in my hands. All right, here's what I'm gonna do. I'm gonna put you on probation for 24 months. It's a non-reporting probation. You stay out of trouble, that's obvious. Stick with your treatment plan. So whatever the plan is with your doc, you stick with that plan and pay your restitution. So work out some kind of payment plan with us. Do your best on that and stay out of trouble. And there won't be any additional penalty. If you end up with new charges while you're on probation with me, then I may very well sentence you for violating probation. You understand that? All right. Listen to me. You're a local guy. I mean, you're just an IPSI. If your treatment plan is not doing what you need, come back and see us and see if we've got any resources we can help you with. All right. So we're going to do okay. We're going to do a no contest to the misdemeanor MDOP.
Judge, Mr. Captain ordered up as a no contest. I think my client is prepared to enter it as a.
Okay. All right. He's made a comment here about restitution, but they don't have the number yet.
Yes, not. Maybe we should bring him in here.
Hey, Joe. That's all right. Ask Kaplan to stick his head in here. All right, Mr. Brooks, you've discussed your rights and options. You understand those rights and the options they give you. All right. And do you understand the possible penalty for the added misdemeanor charge? And understanding all of these things, are you pleading guilty to the misdemeanor? Doing so freely and voluntarily? All right, May 21, 2026, were you in Van Buren Township? All right, why don't you establish what happened?
Mr. Brooks, on that day, May 26th, at about 1 a.m, did you visit a hotel, the Red Roof Inn? Yes. That was in Van Buren Township? Yes. Did you destroy some property that was in the lobby, like a coffee maker? And you did that intentionally? No one gave you permission to do that? Judge, I'm satisfied.
I'm satisfied as well. I'll dismiss the felony.
I'll stipulate that the amount of destruction is more than $200.
Okay, thank you. So tell me what's going on with Mr. Brooks.
Judge, so he is, full disclosure, on probation to you, right?
What's that for?
That was for resisting, obstructing, and domestic violence. So that was my case as well. So I think this is an early bump in the road on probation, but he's doing really.
Was he on probation at the time of the incident?
Yes.
Okay. Okay.
He's doing otherwise really well.
You working? Where at?
Working at, I'm trying to really trying to switch over feds.
He's been doing the work program. He was there yesterday. He's doing more work program tomorrow.
Okay.
He's got a probation review hearing set in July.
What, 27?
July 27th.
About this charge?
I think so.
Okay.
So, Judge, we're just asking that you would accept the plea, place him on another term probation, and give him the chance, at least, between now and that probation review on July 27th, to keep, checking items off this list.
It's with Judge Patton, just so you guys are aware.
With Judge Patton.
Okay, so he's on probation with Patton?
He's on probation with Patton.
Okay. Okay. When did she put you on probation, roughly?
I think it was 12.
May as well.
May 12th?
So this was very early on in his probation, and there's, Judge.
There's something going on.
Here's
Yeah.
mental health.
Okay.
He's had to go, he just received a prescription for an antipsychotic,
Okay.
and he's gonna follow up with this doctor really soon.
Okay. Okay.
Mom.
All right. Mom's on Wexford? Okay. Okay. I'd like to sentence today if I can get something on restitution.
Me too. Mr. Captain, step in here soon.
There's a James Humphreys on it.
He's an attorney, he would answer, and I chatted him and said, I think he's the wrong one, so he could say that.
So do you have a treatment plan? Yeah. Are you doing any kind of counseling, any kind of therapy, anything like that?
Trying to get into the therapist, but they, like, out, so they were trying to like look for some.
All right. Who are you working with on that? Your doctor? Your doctor's trying to find someplace to get you in? Okay.
Or.
Yeah. How often you see your doctor?
Maybe
So on a monthly basis,
3.
every 2 or 3 months? Okay. Do you have any restitution information from Red Roof Inn?
Yes, sir, $2,900.
$2,900?
Yes.
Thank you. I hate to order restitution when the guy doesn't have the ability to pay for it.
Yes, sir, it would have 2 years, actually.
All right, Mr. Martin, anything else?
Just what I said before, Judge, that Mr. Brooks, he's been in touch with me throughout all of this. I represented him in the last case, he's got family support. And I'm glad to hear, he's got follow-up appointments with his doctor. I think once he, nips into mental health issues, then I think everything will be on track for him. He's expressing a lot of sincerity about, staying on his medications.
Yep.
Life is better, he's on medications. So I believe this young man has a chance to succeed on probation.
All right, here's what I'm gonna do. I'm gonna put you on probation for 24 months. It's a non-reporting probation. You stay out of trouble, that's obvious. Stick with your treatment plan. So whatever the plan is with your doc, you stick with that plan, and pay your restitution. So work out some kind of payment plan with us. Do your best on that and stay out of trouble. And there won't be any additional penalty. If you end up with new charges while you're on probation with me, then I may very well sentence you for violating probation. You understand that? All right, listen to me. You're a local guy. I mean, you're just an Ipsy. If your treatment plan is not doing what you need, come back and see us and see if we've got any resources we can help you with. All right? Because I don't want to punish you on this case. But if you just go out there and start doing stuff the wrong way and you don't come ask for help, then you kind of tie in my hands. Understood? All right. Anything else?
Thank you very much.
All right. Good luck, Mr. Brooks.
Thank you.
Oh, hold on a minute. Oh, you already owe us all kinds of money. Is that what you're doing work program is to pay off this money?
I think that's just a condition of probation and Judge.
Okay, so he's already into us for $2,300 on other files. So we've got options where he can do some work days to knock that down. He can do some charity work to knock that down. So explore those options, get this stuff taken care of. All right. So listen to me. If somewhere in the future, you and I are having another conversation on the file I just put you on probation on because you're not doing everything exactly right, but I can see that you've really been trying to take care of your business, then I can give you a little grace. But if you just ignore everything you owe the court and you're having problems, you hear me? All right. So it doesn't have to be money to take care of your files. Restitution's got to be cash. All right. Good luck.
Thanks, guys.
R-O-U-R.
CHAH.
R.
Shore. Shuror. Like roar. Shuror. Got it. Okay. All right. We ready?
Yes, sir.
All right. Sit down. Make yourself comfortable.
Preliminary.
Yeah.
We have a Michigan State Police. Driving lab, the relevant, contraband confiscated in this case. The report has been marked as proposed exhibit 1. It shows that the substance was tested And in fact, this cocaine, I shared it with counsel, I believe we have a stipulation that,
That's correct.
Thank you. And you don't have to jump up to talk to me.
I may have put your.
Sure.
Just for the record,
Thank you.
I'm sorry.
You already got it?
I would just like to note that the amount of, that substance is, about a quarter of a gram, less than a gram.
Okay. Okay.
Thank you, Your Honor. So one witness exam, we'll call Officer Gardner.
Officer. Oh, he's out? Okay. Officer, all the way up front. Raise your right hand. Swear or affirm, tell the truth, all the truth, nothing but the truth. Come on up. Watch your step on my incline ramp. Make yourself comfortable in that chair. Gardner. Gardner. Guard. No. When you're ready, Mr. Capel.
Morning, Officer Gardner. Work for the Romulus Police Department.
Yes.
Taking you back in time to October 5th of 2025 in the afternoon around 5:30. Were you working as a police officer?
Yes.
Where were you at that time?
At that time, I was attached to, an address on Middle.
Do you remember the address on Bill?
I don't remember off.
If you saw the report, would it refresh your memory? Yes, for the address on Middle Street.
Yes.
Your Honor, may I approach the witness?
Please.
Showing the witness page 2 of the police report. Officer Gardner, just review it and tell us when your memory is refreshed.
Okay.
What is the address on Biddle?
9526 though.
Well, at that time, are you in uniform or plain clothes?
In uniform,
Are you in a marked or unmarked vehicle?
in a marked vehicle.
Are you alone or do you have a partner?
At that time, I was alone.
Talk about Middle Street. Why were you at Middle Street?
We were dispatched to a male slumped over the wheel of a white Ford Bronco next to park next to the dumpster.
How much time passed between when you received the dispatch as to a man slumped over the wheel on Middle Street and when you actually arrived?
I don't know the exact time.
Approximately.
Under 5 minutes?
On that day, did you meet a gentleman named John Palmer?
Yes.
You saw John Palmer again, you think you recognize him?
Yeah.
Tell the judge whether you see John Palmer.
I did.
What is he wearing?
A gray hoodie, black pants, sweatshirt.
Noted.
The record reflect the witnesses identified the defendant John Palmer.
Noted.
Where do you first see the defendant John Palmer?
I'm sorry.
Where do you first see the defendant John Palmer?
He was in the white Ford Bronco,
Is he alone or does he have a passenger?
alone,
Is he behind the wheel or is he in the passenger area?
behind the vehicle.
What do you notice, if anything, about the defendant?
He was slumped over the wheel. I also observed a needle on his slab at that time.
What was that, sir?
I observed a needle on his slab at that time.
Was he awakened at any time?
After I knocked on the window, he woke up.
How many times did you have to knock on the window?
I don't remember the exact amount, probably like 2 or 3.
So what do you notice, if anything, regarding John Palmer at this point?
He woke up, took what was off of his lap, placed it to the left of him, and rolled down the window.
What did he do with it?
He took the objects that were on his lap and placed it on the rocks to the left of him.
Can you tell the judge what object you're referring to?
We recovered a capped needle and a Michigan lottery ticket that was folded up containing a brown powdery substance.
But based on what you saw, did you form any inferences as to what might have happened?
Yes.
What inferences did you draw?
At that time, we inferred that he had taken drugs and was experiencing symptoms from that.
You use the pronoun we. Who's the second person?
Officer Green responded with me.
Solomon Green. What happens to these items that you just described in Judge Oakley?
After they were photographed, we collected them and they were placed on evidence.
What happens after that?
These are their lab sheet, there's some issues, the lab be tested.
You mentioned lotto funds.
Yes,
Do you have any experience with lotto funds in your line of work?
There are trees, we learn that typically it's used as a sword for, drug.
Thank you so much. Nothing further, Your Honor.
Counsel, your witness.
General Street, what city is that located?
Right.
Thank you. Thank you, Judge.
okay, Officer Gardner. So you were dispatched for a welfare check.
Correct.
The dispatch related to that there had been a 911 caller.
Correct.
And that 911 caller had said that a man had been slumped over his steering wheel for several hours.
Yes.
You understood your job to be checking on this man's welfare.
Technically, Your Honor, that's not relevant. That's what she does.
She's already answered. Go ahead.
And that's reflected in your report? Yeah. And you weren't there for a fight? No. And you weren't there for any other criminal activity? No. When you got there, you saw that a man was unconscious.
He was slumped on the wheel.
Okay, was that a yes or no, miss?
Yes.
And you saw a needle in his lap,
Yes.
and you recognize that to be drug paraphernalia. And this led you to believe that he could be unconscious due to drug use.
Yes.
And you and your partner asked the questions of his drug use.
Yes.
And you asked those questions because you thought you might overdose.
Your Honor, we would move to strike the answer of unconsciousness. She's not in a position to tell you that. She's not an ER doctor. She can tell you he wasn't awake, but how does she know whether he was unconscious?
Response.
Asking her what she observed. She can observe whether or not somebody is awake or conscious or what have you.
But it's distinction between being conscious.
I'm not asking her for a mental health.
Okay, we're gonna talk one at a time. I'm sorry, go ahead.
I know it's not a really important point here, but there's a distinction between being unconscious and being asleep.
I'm not asking her to make a medical conclusion, Judge. I'm just asking her what she observed.
Okay, I'll allow it. I can weed the shaft from the wheat.
And you were asking those questions because you thought he might overdose.
Objection relevancy. He either had drugs or he didn't have drugs.
What's the relevance?
Judge, I'm asking questions that fall within the statute that my client is charged under. And I'm allowed to ask those questions.
Has to be relevant, Your Honor.
Yeah.
And it is relevant.
Then explain why it's relevant.
It's relevant because this was a welfare check. Somebody was calling because they were concerned for my client's well-being. And I'm trying to gather information about what state my client was in.
Then ask her what state of your client was in. You're asking her the reason she asked these questions, those aren't relevant. The reason she's asking her questions aren't relevant.
And, would you offer my client help?
Objection relevancy.
I'm
What
asking,
matter?
it does matter. I'm asking her what happened in this matter. And how this, situation ended, Judge.
What's it matter? He's charged with possession.
He is charged with possession, Judge, but it's also, what he was using those, drugs for. I have stipulated to the lab report. It matters how those drugs are being used.
How does that matter?
Judge, I will
Does he have a prescription for the cocaine?
not say that. Cocaine drug, but it will be relevant in my mind.
Has to be relevant at this point.
It is relevant at this.
Then you have to explain to me how.
It's relevant because under the statute, there is a good Samaritan, exception to this rule.
That protects the Good Samaritan.
I'm trying to get answers from Officer Gardner to show that that was a warranted, call for Mr. Palmer's welfare. And Mr. Kaplan is not allowing me to do so.
Okay, but doesn't that statute protect the Good Samaritan?
No, the statute protects the person who is using.
There's no law of that. In fact,
Yes, there is. It is.
I didn't interrupt you.
I'm sorry, I thought you were done. You took a pause.
Go ahead.
There's no law to that effect. Now, there is some case law where if you have dope, you take it to the police station, you can relinquish. In this case, he fell asleep with the drugs on his person. How does that make him a good Samaritan? He's a bad Samaritan.
May I please cite the law?
Sure.
It is 333.7403, subsection 3A. May I read it into the record?
I'd rather you hand it to me because I don't do well when people read to me.
If I may have
Yeah.
highlighted.
Highlighted portion. So your argument is that Mr. Palmer's been presented for assistance by another individual?
Yes, that's correct. And it's relevant that I asked Officer Gardner if she procured assistance because that's what it was called.
Any argument to that?
How can staff?
Okay, counsel, I've asked him a question.
Anything related to this witness is hearsay. I know this is tangential. It's all hearsay. We can't cross-examine anyone who called, but it's not even relevant. If counsel were correct on this, you could have a drug kingpin who falls asleep at the wheel, and all the drugs found in his car can't be admitted. That's nonsense. There's no law about that.
Yeah, well, let's argue the language of the statute. The statute says an individual who seeks medical assistance for himself or herself, or who requires medical assistance and is presented for assistance by another, has an exemption. Her argument is because of the dispatch call, Mr. Palmer was presented for assistance by another.
First of all, we have the hearsay issue. She can't overcome. There's no doubt about it. Statement made out of court for truth of the matter certain, so we don't know why anyone called. You might just have somebody speculating. We don't know. Somebody sees a person slumped at the, you're gonna call it. Could be an unconscious person, it could be a guy who's been shot, could be all kinds of circumstances. This unknown caller, Judge, doesn't have personal knowledge, can't tell you why the guy was slumped behind the wheel.
Would you agree with me, counsel, that the reason for the call is pretty important for your argument?
I-
And would you also agree you can't establish that today at the probable cause hearing?
Check. Probable cause.
That's a yes or no question, counsel. How are you going to establish it without the person that called?
Would you like me to answer yes or no, or would you like me to answer?
I'd like you to answer yes or no. Are you going to be able to establish that today?
Yes,
Good luck. How are you going to do it?
Judge, I'm trying to, again, procure answers from Officer Gardner as to why she was there, how she was able to assist Mr. Palmer in doing those things. She has answered affirmatively.
That doesn't do it though.
That she was there.
Presented for assistance by another individual. So she can't tell you why that individual called.
Judge, the purpose of this law is for.
Counsel, I understand the purpose for the law. That doesn't help us today. Today's a probable cause hearing.
Understand that the purpose also for the probable cause hearing, yes, is to establish.
Don't lecture me, counsel.
Um,
I've been doing this longer than you've been alive. I understand the purpose for a probable cause hearing. Okay? I'll allow you to ask your question.
I'm sorry. Just one. And Judge, I would like to point out that Mr. Kaplan did open the door to the 911 call in his direct examination. I did not object to hearsay to him. And he did not object to hearsay when I asked the question of what the 911 caller had
It
said.
wasn't hearsay when he used it, counsel. It was meant to explain why she went to Biddle Street. That's not for the truth of the matter.
I understand, Judge, but,
Back to your questions.
and did you call for help?
Did we call EMS?
Yes,
To petition the bill, yes.
yes. Okay,
What'd you say to what, Dick?
To petition him.
Thank you.
okay. And Romulus Police, or, excuse me, not police, fire department, they did respond, EMS came?
Yes.
Okay, and then they took him to the hospital?
Yes, we're, officer grade petition.
Okay. And you did that because you believe that he needed that help?
For mental illness, yes.
Okay. Thank you.
No more witness questions for this witness?
No.
Any redirect?
Very great. Great to have them. You had other occasions where you were summoned, dispatched to an area of a person sleeping or slumping behind a wheel.
Yes,
Are there many circumstances that could cause that,
yes,
like physical illness,
yes,
like overdosing,
yes,
like using too many drugs,
yes,
lack of sleep?
yes.
Any recross?
Yes.
Go ahead.
You search the vehicle, right? It's,
Actually, outside the scope of my back.
Judge, it's relevant. I'm just trying to lay a little bit of foundation.
But it's outside the scope.
May I approach this witness?
Sure. Morning, counsel.
Do you recall writing a report?
Yes.
And do you recall stating in your report?
We have checked, the report is here saying she could be impeached if she made an inconsistent statement.
Okay.
Anything in the report is here.
Do you recall evaluating whether he needed medical attention due to the state that he was found in?
Checked and relevant.
It's within the scope of what he asked.
I'll allow it.
Yes.
Okay, and that's consistent with your report, is that correct? Okay. And so you were trying to help him, not just for his mental illness, but for the state that he found him in.
We were trying to establish if he needed medical assistance or the state he was found in.
Okay, and you determined that to be in the affirmative, is that correct?
For possible overdose, no, he did not have any medical attention for that. Medical attention was called for the petition, the comments he made while in the back of the patrol car.
Okay. Just one minute. Okay.
Sure.
Do you recall retaining a monitor him because he was trying to ensure that he was still alert and responsive?
Checked and relevancy.
Again, this is within the scope of,
I'll allow it.
were you trying to ensure that he was still alert and responsive?
Yes,
And that's because of the state that you found him incorrect.
as well as because he told us that he had used 20 minutes prior.
Okay, so that's a yes.
Yes.
Thank you.
He told you that he's
Hold on. How many shots we gonna have at her?
supposed to no redirect, but if something new is opened up, don't have a chance,
No.
maybe.
And
People are.
no other witnesses? You can step down off the guard and watch your step on my rant. Safe to assume we don't have any defense witnesses today?
No.
I'm ready for argument.
Thank you, Ron. Very simple case, happens every day, comes in any large municipality. People fall asleep in their cars. Why? Sometimes, why do people fall asleep in their cars? Sometimes they're tired. Sometimes they're meditating. Sometimes they overdose. Sometimes they consume too much alcohol. Sometimes they're hiding. In this case, the officer responds, they see this John Palmer gentleman slumped behind the wheel, and they don't know, Judge. They acted appropriately. I mean, the guy could have been in the throes of overdose where he needed medication. We don't know that. But we do know, Judge, that he was in possession of drugs. And very interesting, brought out on recross was, he told them. He said, yeah, 20 minutes ago I used cocaine. Judge, it's possession of cocaine, not there's some perhaps at circuit court level. If so, we will learn something new today. Thank you, Ron.
Counsel?
Yes, Judge. The defense had presented, Your Honor, with the statute, 333 civil force charges. So section 3A is a Good Samaritan, exception to simple possession prosecution. Judge, that exception requires that the police are there for a medical emergency because of drugs. That is reflected in her report, that is reflected in her direct, testimony, that the people are quite honestly ignoring. She found a cat meal and a lotto ticket in his lap. He was slumped over not just because he was simply asleep, but because he had been using drugs. That was an inference of a drug overdose. The people had stated that, that Officer Gardner had testified that my client had said that he had only used 20 minutes sooner, but she had also, excuse me, I'm sorry. She had testified that the 911 caller had said that this person had been slumped over the wheel for several hours. It is also required that the drugs are in a small quantity. When I made the stipulation to the lab report, I did note for the record that it is about 1/4 of a gram of drugs. Less than 1 whole gram, and I'm sorry, I had sugar packet for you, Judge. A sugar packet, needle packet, is 1 gram of drugs. Mr. Palmer had on him 1/4 of that. That is most certainly the amount of personal use. And it is a defense only to simple possession. So nothing about a kingpin, nothing about somebody who has a ton of drugs in their car. It is a statute or a law designed specifically for somebody in Mr. Palmer's situation. Police arrived because of that 911 call of an unconscious man. They find that unconscious man with needle in his mouth. They get him the medical attention. And they find a very small amount of drugs on him. And again, Judge, this is something that is designed for people just like Mr. Palmer, and as such, rule over dismissal. And I would also, like to say, the Michigan Court of Appeal case that highlights this perfectly. This is People of the State of Michigan versus Justin Edward Duha. The LC number is 22. It's a published case 3115. And it's a very similar situation where in which an individual is overdosing. Somebody calls 911 to get him medical attention, and the Court of Appeals found. And it is important to note that this person also said that he did not want help, or he did not want medical attention. And the Court of Appeals found that this did fall within the Samaritan exception of the statute. And if I could please present this to the court.
Sure.
Presenting the people of the patent.
Mr. Kaplan, any response?
Okay. Practicing a long time. Generally, attorneys will provide reports to the opposing attorney. So I found out about what. That's fine. Judge, even if you find it's cockamamie claim, it's an affirmative defense, and they at circuit court would get the burden of coming forward in evidence, and then we would have to repel it if it is an offense. But in this case, Judge, not only did he have a dope with him, but he admitted he had just ingested it. She can't tell you that any good Samaritan was calling about drugs. She just wanted to know, meaning whoever called Judge. And I can't cross-examine it. I'd like to cross-examine that person, Judge. And, I would ask some probing questions of them. And ultimately, you know what that witness would say, Judge? If she exists, she'll say, I don't know. I saw a guy slumped over the wheel. Thank you.
Thank you both. I'm going to bind over. Number one, I don't think it's an appropriate argument for probable cause hearing. And number two, I do not believe this is what the statute was meant to, and it does not fit the facts of the Duha case. Duha's case, the defendant's mother called after she. I just looked in and checked on him, and he was not okay. He was unresponsive. I tried to wake him up and shake him, but defendant did not respond. Totally different situation than some anonymous caller saying, hey, there's a guy sleeping in a car. Bound over. AOI 7726, 9 a.m. Bond will be continued. Good luck downtown, Mr. Palmer. Exhibits and case law. Yeah. No, it's signed, yeah. Michelle, how do you say your last name? Fauser? We're waiting for your attorney. You know, it's fun. Seems like June is taking forever to get through. I've never felt that way before. I don't know if it's June, it just seems like, it's just like lingering.
But that's okay, we don't want.
I know, and I don't know if it's because I was gone for a whole week or something. Cause you would think that would make it move go fast.
Well, at least you're enjoying it.
Hmm?
At least you're enjoying, you're not.
Appearances on the People versus Turner, please.
Your Honor, Stephen Gale, on behalf of the people.
Hey, good morning, Your Honor. David Cripps, P 34972, appearing on behalf of Julius Tremaine Turner, County Commissioner.
Julius Tremaine Turner.
Thank you. All right, I understand we got a waiver.
Yes, sir.
All right.
Cited for the record, we filled out the form for your Honor.
I'll put it in the file.
Thank you, Your Honor. Judge, we have a wait for random counts 4 and 9, Your Honor, as well as an added count 13. Judge, added count 13 would be possession of cocaine less than 25 grams. Your Honor, the other counts would be dismissed, other than 4, 9, and.
And go back to, there's an ad account. So we're gonna waive on 4 and 9, 1 through 3 and 5 through 8 are dismissed, correct?
Yes.
And we're adding another count. So there's a count 10.
Now, you had count 13, Your Honor.
And what is that?
Possession of cocaine less than 25 grams.
Got it, Heather?
Yes, I do.
Do you like her?
Okay. Agreed?
We agree, Your Honor.
All right. Sir, do you understand your rights and options after discussing same with Mr. Krebs? No, that's all right. You understand your rights and options?
Yes, sir.
You understand the purpose for an exam? And you understand by waiving the exam, we're sending the file downtown to the circuit court level, not at the district court level where we're at today. And are you waiving freely and voluntarily? All right, gentlemen, you satisfied with the waiver?
Sorry, Your Honor.
I am, Your Honor, and we reserve all rights to raise a 180-day rule if I can perfect it at the circuit court level.
Understood. All right, so I think I've got all.
Your Honor, may I trust the court on the tangential issue?
Sure.
It's another case. It's being handled in the Wake County court system through 36 districts. There are numerous charges, Judge. It's really duplicative as to what.
Mhm.
And therefore, I'm not going to proceed on that case, Judge. It was dismissed yesterday in Judge Child Support without prejudice.
All right,
Thank you.
and that's got nothing to do with this file. You just want it on the record.
Yes.
Understood. All right, so I'm binding over, AOI date will be next Tuesday at 9 AM. I need signatures for you two. And then I'm done with this file. Mr. Attorney, you've also got a misdemeanor file in our court, a domestic violence charge. We're just gonna adjourn that out to July 7th at 10 AM.
What, no complaining is on that.
I can tell you what I got in the file. According to my complaint in the file, sir, it's Alicia Joy Williams. And the date would be October 5, 2024. You're on a personal bond on that file. We'll continue bonds on both files.
Your Honor, wish for me to try to settle that, please?
So we're doing
Yeah.
a pre-trial.
Yeah, we're doing a final pretrial, see if the victim shows up. That might make it go away.
Mr. Gavin, once he gets allocated, you always have.
My pleasure.
He's a pro. Thank you, gentlemen. Good luck downtown, Mr. Turner.
You and stuff. You can see through the.
Good morning, Miss Manorino.
So it's.
Wonderful. Who's that on? You as well, Mr. Krebs. Thank you, gentlemen.
Yeah, look at the form. Right?
Yes.
I'm sorry?
Good morning, counsel. What do you got?
You have the forms?
Oh, I found it because I'm not sure. Yeah, me neither, but that's why I said, wait, and then. Yeah, not me. I know, this is why I was like. You're welcome. There was another person. That's why it's not this.
Yeah, that confused me. That's why I didn't write a number. I just thought added charge.
I'm gonna get him downstairs. Take care of that, every day.
You as well.
Oh, that's my sister this morning. So you know, like you have people that you get on the phone with and you don't even need to say anything. My stepsisters. And my sister got on the phone with her last night. My sister fell asleep. Karen's a big, yeah, I'm saying she's just quiet. Oh, no. I woke up about 9:45 and my phone just sitting there.
So your stepsister probably figured she was off the connection or something.
When my sister's home and I go unless she heard you snoring. She would've been in the phone.
Oh, God, that's hilarious. That's hilarious. Susie called the doctor today, Sunday,
Mhm.
and get the stepmother got on the phone. I've got sign candidates. Had to be. I'm like, I was.
I
Mr. Norris.
My apologies. Can we just look at it?
Yeah. Yeah, maybe you can read it.
I'll let you know that. If like I'm at work, I'm like, I'll call you later.
Susie's got a couple of friends that she always puts off calling them because she knows when she calls them, it's gonna be a 45 to an hour.
Yeah, exactly. And you love them just the same, but you just.
It's just like, it's, and I'm like, you just gotta get better at getting off the phone. She says, I can.
Fine.
Are we ready? All right, appearances for Mr. Norris. Appearances.
Over the year staff, thanks to the defender service by Chicago folks, P89, 343, we have Mr. Norris, Mr. Norris, you can say your name for the record, Sean Norris.
Thank you. All right, Mr. Folks, right? FOAKES?
Okay, yes.
Oh, there's an L. Okay. All right. So I've got a plea agreement on case number 0492, but did you talk about 0050, which is the operating while intoxicated third? Okay, that's a straight waiver. Okay, all right, and on the 452 file, we're gonna add a count, dismiss count one, add a use of cocaine, 1 year misdemeanor. Okay, all right, so we've got case number 240492. We're gonna plead to the misdemeanor on that one. And then 0050, we're just gonna waive. Let's do the waiver first. Mr. Norris, you understand your rights and options after talking to counsel about those?
Yes.
And do you understand the purpose for an exam?
Yes.
You understand if you waive the exam, that means we're gonna send this file downtown for you to deal with the circuit court and not at the district court level where we're at right now. Understanding all of that, are you entering a waiver freely and voluntarily?
Yes.
Counsel, you satisfied with the waiver on that file? Thank you.
What was your earnings again?
Great.
All right, so on the waiver file, we're gonna do an AOI on July 7 at 9 AM. I'll continue bond and wish Mr. Norris luck. You're welcome. I'm also gonna need signatures from you fellows. We'll get that in just a minute. All right, and as to 0452, you understand the possible penalty for the added charge today, sir? And you understand the possible penalty for that charge? And are you pleading guilty to that charge freely and voluntarily today? On July 29, 23, did you come in contact with Belleville officers? Or officers in the city of Belleville? And at that time, did you have in your possession some cocaine? Counsel, you satisfied? All right. I'm inclined to schedule Mr. Norris for a pre-sentence investigation and bring him back for sentencing date. Is that gonna work?
Does-
Sir, are you on Slater Street in Toledo? All right, so I've dismissed the felony. I've accepted your plea on the added misdemeanor charge. I'm gonna send you downstairs to make a date with the probation department to come back for an interview. And a sentencing date. I'll continue your bond on that file. And looks like you owe us money on some other stuff. You know about that?
No.
2021 Van Buren, we had a fail to display valid license, drove without due care and caution. Those two, it looks like you owe us just under $1,000. 962. Are you in a position to get some kind of payment set up on that?
So, yeah.
All right, set something up before you leave if you can.
Judge, please, okay, I mean,
I'm sorry, say again? Go ahead.
that, but it happened, was not objecting to this being a, non-reporting probation, seeing as he lives in Ohio as well. And I won't say else, but now it's that.
Okay, and I'll probably go along with that. Let's see what the PSI says. All right, have a good day, folks.
Here you go, Adam. Third. Oh, this is mine, yeah.
Way over that.
Mullins, Mr. Rankin's here. I will see that kind of.
Thank you.
Yeah. I mean, really, actually, look like a funny, yeah.
Hi, Nancy. What are you doing?
Other edit.
Things or misdemeanors. What usually do them? I don't know if it's because of all the ASI is man. But the ASI is not just okay. Same. Yeah, I'm sure we don't have mine because. Yeah. And maybe. Yeah. Maybe. I was actually. Yeah. But I just because of that. I just did a bunch of it. Yeah, like that, and then. So we just need to make sure that it's the outside and stuff. Okay. Got it. Yep.
All right. Bye. Nice to see you. You too.
Morning, Judge.
Good morning. All right, appearances on the People versus Mullis.
Oh, sorry. You guys,
Mullis.
Judge, is this in regards to the malicious destruction of personal property? She has.
Sure.
I'm only on two of them. Mohammed on behalf of the people, in regards to the malicious destruction of personal property as well as the DWLS case.
And good morning to your honor court staff, Jonathan Roberts, P 86428. On behalf of Mr. Mullis, asked two files ending in 0407-SM and 0406-ST, which are being covered by Mr. Mohammed. Mr. Mullis, can you please state your name for the court?
Thank you. You can have a seat, sir.
Judge, in regards to the DWLS account for case, I'm moving for a nolle process in the interest of justice. It's my understanding the city had prosecuted on that case already, so there appears to be some potential double jeopardy issues.
Okay.
So in the interest of justice, I'm moving to dismiss that case.
No objection?
Without objection.
Thank you.
In
As,
regards to the malicious destruction of the property case, Judge, the pleading witness was subpoenaed to be here. She's failed to appear. The officer did make attempts to serve the complaining witness in this state of her subpoena. He informed me that on 6/17, he attempted to serve her in person. On 6/18, he left voicemails on Friday, and on Friday morning, he sent an email with a subpoena explaining that her attendance was needed for this case to move forward. There was no response. So based on that, people are unable to proceed.
thank you, Mr. Roberts.
On that basis, Judge, dismiss without prejudice.
Granted. All right, thank you, Mr. Mohammed. All right, Mr. Lecky, now your appearance.
Your Honor, Jake, let me carry on behalf of the people, P 8
And again, good morning to your honor court staff, Roberts, P 86428. Representing Mr. Mullis, on file ending 0453-FY. Mr. Mullis, is to my left. You can take it to the court.
Thank you. Have a seat, Mr. Mullis. Are we ready to get started, guys?
Yeah, for the record, I believe Mr. Lecky is intending to add certain charges that just like those to be noticed prior to the exam.
Yes, Your Honor. So at this time, the people are looking to add the failure to stop after collision. I don't have the MCLs right now. I'm sorry. And the license plate, registration, title, and lawful use. Like I said, I can look at the MCLs.
Okay,
but they are misdemeanors. However, I think testimony is going to come out. Work permitted, I think that is something.
okay. All right, ready to get started on the exam?
Right.
Let's call a witness.
But this time. We are going to ask that officer. Kind of hold on, we stand.
Officer, come on up.
Officer, probably good for us, small. Here, I'm going to ask for a. Mutual order of sequestration. Thanks.
Okay, granted. Raise your right hand. Swear or affirm to tell the truth, the whole truth, nothing but the truth today. Come on up here, watch your step on my ramp, settle in that chair. Holcomb, HOLC. When you're ready.
Yes, and before we begin, we are going to be offering evidence under MCL 76827C. Is the hearsay exception that allows domestic violence incident to come in. We see that it being entered in through this witness, I believe her testimony will reflect that all the elements are met to allow that exception.
All right. Proceed.
Okay. Good morning, Officer. How are you employed?
With the city of Belleville
As what?
as a police officer.
Okay, if you could, I'm having a difficult hearing a few things. Yes, perfect. And how long were you employed in that capacity?
With the city of Belleville approximately a year. Overall,
Yes, either.
overall 19 years as a
Okay.
police officer.
And what do you do as a part of your duties as an officer in the city of Belleville?
Routine patrol, which was check stops, responding to police runs, traffic accidents, things of that nature.
And did you respond to a police run at a 213 Aberdeen Port in Belleville, Michigan on June 1st, 2026?
Yes.
And was that, and what time of day was that?
It was in the evening, it was 21:30.
Judge, for the record, I believe Officer Holcomb is reading from a report. I just want that to be shown for the record.
Yes.
Noted.
Going to-
Go ahead.
So. Now that your record is placed face down in front of you, what time did you arrive for it?
We were dispatched, I was at the location within 30 seconds of dispatch.
And Judge, if we could get clarification, you said B, so who was you referring to?
Fair enough.
Officer Pearl.
Okay. And yourself, correct? Okay. So. You both arrived at that location, what did you see when you looked at?
On my arrival, I saw some reverse lights coming out of the driveway of the location.
Okay, of what do you know what vehicle was?
It was a Chevy Equinox.
Okay, and did you at any time stop that vehicle?
I activated my overhead lights, and gave verbal commands for the defendant to pull back over and drive.
Okay, so you stated defendant, who is that?
Cody Wallace.
Okay, is that person? And this is the individual that you saw, right?
Objection to leading, Judge.
Sounded like it. Rephrase.
And this individual, who is that? Who's the driver?
The driver of the vehicle was Cody Wallace.
Okay, and that is the person,
Judge to leading.
and is that person in the court?
Yes,
Okay, can you point them out, they know that?
yes, it's driver behind him, jumps.
Noted.
Thank you. So at this time, Cody Moss, that is the person that you stated earlier was the defendant, is that?
Correct.
Okay, so. Now. What did you see? That vehicle do?
Reversing out of the driveway.
Does it do anything else?
came very close to striking my car, but swerved to miss my car.
So and when did that happen?
Upon my arrival,
Yes, how shortly after?
Indian.
Okay. So just for clarification. You are driving to this residence, you see this vehicle back out, and then you actually go, is that
Correct.
okay, what happened since?
Right, and next you said?
Yeah.
Mr. Mullins follows my commands and pulls back into the car.
Okay, so down to the street and then goes back into the car.
Correct.
You notice anything,
Well, Judge advocated that, I've got this confusion of the testimony. She never said that he was in the street. She said that he was still in the driveway, so I asked if that portion be stricken.
I asked if she would pull over the street, she said yes.
Clarify with some follow-up questions.
So what did you see this car do? I want you to explain every single detail you saw this car do.
So I see the backup lights as I bend the corner to get to the location. I, at that point, speed up because I anticipate him attempting to flee. When I get there, I activate my lights. He's
there?
the 213 Heavy.
Okay, keep going.
I'm in front of the driveway, I activate my lights. He's still reversing, swerves to miss my car and enters into the roadway.
Okay. Then what?
I give verbal command to return to the driveway and he follows those verbal commands.
Okay. Then what?
Then, Officer Pro pulls up at that time and we attempt to separate the parties, Jennifer and Cody, to figure out what is happening.
Okay, so at the time this car pulls into the driveway, there is another individual there, you identify, is that correct? Okay, and who did you say that was?
Jennifer DeBoer,
Okay, and where was she at?
she was also in the road. On full.
What happened after that?
I then spoke with Jennifer and my partner spoke to Cody.
Now, in your conversation with Jennifer, how long after the call was that?
A minute or two.
Okay. And what did she indicate to you?
And how it will judge this. That's what you're saying.
So this is the hearsay that we're getting in under 27C. It is a instance of domestic violence. It was shortly after this officer has indicated, court will hear it, that it is an instance of domestic violence, so it comes in our desk.
Anything else, Mr. Roberts?
What like that?
I'll go ahead.
So what did that individual indicate to you?
She indicated that she had invited Cody over to speak in public service.
Okay, I'm gonna
Also know that there was an active PPO in that at the time of this. She said that the conversation turned into an argument. She asked Cody to leave. She said if you can call 911, and she said that Cody said if she called 911, he was going to kill her. She said that they had a struggle. He put her against his car, making car parts fall off of his car and tearing her shirt, bruising her. She said that at that point she tried to call 911 again. Cody slapped the bone out of her.
So I want to stop you. So I see you're looking at something.
I mean,
So I'm seeing what exactly she stated to you. Do you remember off the top of your head?
well, this is my police report that I did,
That wasn't the question. The question is, do you remember?
but not 100%.
Okay, so are you referring to something to,
And Judge, I'll renew my objection, so the issue here is that the statement needs to be reliable. And if she's reading from the report, I think she just testified that this is really good reading from the report, which is right next to her record. There's asked for clarity as to whether or not she can remember, and now it's I can, but not 100%. We're straining the purpose of this rule, which is to allow for reliable testimony. I just want to leave my objection to hearsay because I don't think this is following what it's going to see at this point.
Mr. Leckie.
Yeah, I was in the middle of trying to get there, but I was interrupted during questions, but I was continuing.
Try.
Any additional information? So. You can explicitly remember word for word at this moment what she said.
There's a sequence of events. I don't want to misquote this.
Well, just answer my question. No,
Question.
can you explicitly right now remember word for word exactly what she said? Okay, but on that day and that time, you did have a conversation.
Correct.
You did detail that in the police report, correct? Okay, now is that police report what you had in front? Now, if you had to, you could remember that conversation, correct?
Objection, Judge, that's speculation and speaking.
Could you remember a conversation based on it? So, how this procedure works is if I ask you a question of what she said next, if you say, I don't remember, then we have to go through is there something that would help you remember that conversation? So is there something that would help you remember that conversation? Okay, and what is that? Okay, so take a minute, look over that. And then once you have, flip it over, and then we'll start this from the beginning, if that's fair. There are a few of them.
I don't know if it's been ruling, but I'll let her.
I'm allowing it.
So you flip your police report completely over. Take your memory refreshes to your conversation with that victim that day at that time. Okay, and what did she tell you? Let's start back from the beginning to work our way, okay? So what did she say to you?
She said when she invited Cody over to the conversation regarding Wisconsin.
Okay, and then what?
She stated that after it turned into an argument, she asked Cody to leave. As she was asking Cody to leave, they ended up in the garage from the home. She said Cody pinned her against his vehicle, causing damage to his vehicle and bruising on her. She stated that she was unable to break free from that, and he pinned her against the storm door in the garage and put his arm around her neck, choking her.
Okay, and what else did she describe?
When I asked her on a scale of 1 to 10, her level of choking, she said it was 10. She couldn't breathe, and she believed that he was going to kill her.
And what else?
Stated that lasted for approximately 15 seconds.
Anything else?
After that, she said she tried to call 911, and he slapped the phone out of her hand. She yelled in the house for her daughter to call 911. Daughter came out, he released any grip from her, and she stopped the call 911.
Anything else? Then?
After she called 911, she said that he realized that she called 911, and that's when he got his vehicle to police.
And that's where you see him next.
Correct.
Okay. Do you see anything stand out about? So you talked to her. Did you look at the car that punched?
Yes.
What stood out to you about that car?
There was a mark on the rear passenger bumper or panel area consistent with.
Objection, Judge, I think that's going with speculation. She just her observation.
Okay.
Fair enough.
What did you observe?
I saw vehicle damage on the property.
Okay. And did you see anything else of any what else did you see?
I saw vehicle damage on a Jeep that was parked in the driveway.
Okay. And can you describe the damage?
There was paint transfer on both cars. Consistent with
Objection, Judge.
possible collision.
Okay.
So that was speculation, so the collision piece, to that.
Any response to speculation, objection?
It's fine.
Move on.
So you saw paint marks on both cars, is that right? So one car was what, the Jeep was what color?
Jeep was black.
Okay, and what paint trade did you see on that car?
I saw silver paint on the Jeep,
Okay, and what car did you say the defendant was driving?
a silver Equinox.
Okay, and so that car was silver, as you just stated.
Correct.
What color paint is on there? Okay, and was there anything else around that scene that you noticed?
There was broken parts from his vehicle in the garage. From when he entered.
Objection, just as speculation, that.
It is.
So, you know, without speculating, what, you can only testify what your.
Garage.
And okay, now. When you, no, this is just you. What did you do next with that information you okay?
I advised my partner that Cody was arrested for these.
Okay, and then did you arrest? Now, when you arrest him, do you look up his, well, he was driving, is that right?
Yes.
Okay, did you look up anything about his car?
Member did not.
Okay, so your partner, Officer Brooks, then. Did you look up his? And does that include his registration status and all of that? Yeah. And you saw those parked cars, did you see either car on video? Did you see anything else besides his vehicle reversed?
Upon my arrival, I observed the reverse lights. And I saw the reverse lights go off and him pull forward. And then him start re-reversing, and that was when I was directly behind.
Okay, so, and him being the defendant, so you saw the defendant's car's reverse lights go on.
Yes.
Then go forward. Then it changed and went back again. Oh. Your Honor, I'm looking for.
Mr. Roberts, your witness.
Good. All staff, Judge Officer Holcomb, how are you doing? Great, thank you. Now, have you ever interacted with Mr. Wallace before? And that was during your time as a Bellevue police officer? You've also interacted with Jennifer before? And for this case, you're saying you had that conversation with Jennifer the day of the incident, fair to say? So of course, as officer in charge, you wanted to make sure that Jennifer could testify if she was willing to, correct? And as part of that, there was subpoena sent to Jennifer.
I did forward her via email.
You also know that there are other cases involving Cody Wallace and Jennifer, correct? And there have been attempts to serve her with subpoenas for those, correct? You're aware that at least for the more contemporaneous cases, she was attempted service on June 17th, is that correct?
That's what I just said.
As well as June 18th?
That's what I just said.
Well, Your Honor, that's hearsay.
Oh, she doesn't know this. I don't find it. If you don't know, you can just say you don't.
I just heard it in the previous,
Okay.
Understood.
So I asked to be strict.
Stricken.
So with respect to your subpoena efforts, did you make any contact with Jennifer after that day? Okay. Did you attempt to go to her house?
I think the next day. but I've been on town for the last 10 days, so.
So I'm assuming you kind of delegated that to somebody else.
I forwarded a subpoena. I shipped and Sunday, Monday.
Okay. Any other contact that you've had with Jennifer since that evening?
Oh, one day after. I was followed.
Now, as part of this case, because it's domestic violence, you typically prepare a domestic violence report, correct?
Yes.
And that is to document your observations on the scene there, as well as document any injuries that you see on a victim, correct? And the importance of that is to make sure that even if we're dealing with the case from months away, years away, you can remember what was fresh in your mind at this time, correct?
Yes.
And for any of those reports, you'd agree with me that you want to be extremely detailed and you want to be accurate. You prepared one of those for this case, correct?
Yes.
And I just want to go over what you noted in that report. It's fair to say, in that report, you denied that there was a PPO against Mr. Moores, fair?
I'm not sure. I believe there was an active PPO at the time of this.
So my question is a little different. In your domestic violence incident report, it's fair to say you denied that there was a PPO against Mr. Moores, correct? Would reviewing the domestic violence incident report refresh your recollection? Your Honor, approaching opposing counsel witness in turn, report will be marked with advance A for identification purposes. Page, that's something happy. Can you see the screen, officer?
Yes.
Can you tell us what this is? Is this
Speak up, counsel or officer. Thank you.
the report you prepared for the incident involving Cody Mullis and Jennifer on the date that you stated?
Yes.
Just want to review it. If you can, let me know when your memories refresh.
See that? That was probably accidental.
So to answer my question, in the report that you stated clearly has to be accurate, has to be detailed, you put that there was no PPO against Mr. Mullis, correct?
And that domestic violence report, correct. In the incident report,
So my question just about the domestic violence report. Thank you, officer. You also made notations as to injuries, correct?
yes.
And the helpful thing about these incident reports is that there's actually a figurine where you can mark injuries, correct? And you're expected to mark injuries on the figurine so that we have a detailed understanding of what injuries were fresh from the incident, fair to say? On your domestic violence incident report, you make no notations of injuries on the figurine, is that correct?
I don't have that yet.
Would reviewing again refresh the recollection? Permission to approach again, thank you. With defense A for the record. And just let me know when you're ready.
Okay.
So I'll ask again, officer, on the incident report, which is supposed to be both detailed and accurate, you don't make any notations as to injuries on the figurine, correct? There's also a place where you can indicate whether there was strangulation, correct? Like checkboxing? You're not sure? Would reviewing refresh? Is that yes?
Yeah.
Approaching with defense A. Let me know when you're ready.
Yes.
So there is a place where you can mark whether you saw signs of strangulation, correct? You did not mark that there were signs of strangulation in your incident report, correct? What you do know in your incident report is that you have somewhat of a problem with Mr. Mullins.
No.
Well, you specifically know that Mr. Mullins has arrest for domestic violence, but he doesn't have any convictions. So Jennifer's not here today, correct?
Right.
To the best of your knowledge, she hasn't communicated to you about the case.
Right.
You're still testifying about that incident, fair? A moment.
Nothing really good, thank you.
Mr. Lecky?
Okay, very good.
Oh, so you can step down. Watch your step on that ramp. Mr. Lecky, before you call the next witness, are you going to call another witness? Let me take care of a plea. Mr. Duncan on Ibrahim.
Well, Judge Roy Duncan appearing on behalf of the defendant.
Good morning.
We've had, in this bar, today, the date and time set for bench trial, there's been an agreement that my client can keep going to allow an unlicensed person to operate more vehicle and to impeding traffic. Infraction will be dismissed and the driving unsuspected will be dismissed.
Thank you. Any objection if I just process one file, just dismiss the civil infraction outright and just hit him a little harder with the money on the misdemeanor? Just less work for Heather. All right, Mr. Abraham, do you understand your rights?
Yes, I do, Your Honor.
Understand the options those rights give you today?
Yes, Your Honor.
You understand the possible penalty for the added charge of allow unlicensed driver to operate?
Yes.
Understanding all of that, are you pleading guilty to that charge today freely and voluntarily?
That is correct.
Sir, did you operate a vehicle on March 9, 2026 at a location near Harrison and Cherry in the city of Romulus? At that time, was your license suspended, revoked, or denied? Counsel satisfied?
Yes.
I'll accept the plea to the added charge, dismiss both the original charges. What should I know about Mr. Ibrahim before I sentence him?
Yes, that would be great for me because he's eligible to have hearing, but obviously if he's put it one on his record, he wouldn't be happy.
Yeah.
So he's gonna retain me now. We're gonna go ahead and.
Good. Good luck with your license.
Thank you.
All right, you working?
Yes.
Where at? How long?
Green Mountain.
Okay. Anything else you want me to consider before I sentence?
Move forward, be more responsible with my actions and do the right thing, to go about the right process, that be ready to do the honor.
All right. You don't have a hearing date yet.
No, I had to wait and see what happens.
Yeah, but he's eligible.
He don't.
Okay. What, just curiosity, time frame? How long will it take you to get in front of somebody?
Gonna get a substance abuse evaluation, so that's gonna take probably about.
Yeah.
3 weeks.
Yeah.
3 to 6 notarized letters.
Mhm.
And he's gonna fill out a form, I turn that in, and when I do turn that in, sometimes I get a hearing in 4 to 5 weeks, sometimes it's 12 weeks, it just, I think depends on how busy.
How they fall.
There's 10 hearing officers.
Okay. All right. All right, I will do fines and costs, $750, and I'm ordering 4 days on the court work program as an alternative to jail. You pick which days you want to work. We're currently scheduling Monday through Saturday. Can you pay the $750? How much is bond money on that one? Okay, so the civil infraction's already got $230 on it. We'll apply that to the $750. Can you pay the balance today or do you need options? All right, pay that today and schedule your work days. Any questions?
No.
All right, good luck with your license.
Thank you.
Sure.
I was just gonna let you know, I visited
Good to see you.
Thank you,
You're welcome, sir. You want to tell Jacob I'm ready to go? Mr. Lecky, who's your next witness? Come on up, Officer Pearl.
Okay, well,
Answer stipulation? Just hang out right there.
so stipulation 2 is. Invalid license. That the license plate he was using was not his, it was from a Ford F-150. The license plate on this vehicle was a license plate to a Ford F-150, not.
And he wasn't driving an F-150.
And that his license plate, registration, and insurance were all invalid.
Solely for the purpose of exam, I don't want to say stipulate because still proves, but I would not object to those being part of the final of the argument, and I will not make objections as to those being medical.
Is that helpful? Put him on.
That's,
Your call.
Your Honor, for Bindor as to the additional counts 2 and 3.
Okay, we don't need you. Okay. All right, so no other defense or no other prosecution witnesses, correct? Defense putting any witnesses on? I'm ready for argument, guys.
One, which is all we're here for the exam today.
Yep.
We testified from a officer who heard from the victim of the victim. As we heard testimony, that statement was a domestic violence or a summary of a domestic violence incident of a threat or physical force. It was made in a timely manner, so it is credible. It is credible. I believe she indicated that she was strangled. It was a rating of how strong the strangulation was, from 1 to 10 was a 10. She did say she did be pretty. Therefore, I think count 1 we consider the other reasonable doubt, at least for purposes of the exam. Now, count 2 and count 3 read as follow. For the additional count 4, the failure to assist collision, we heard testimony that there was some broken car parts and there were some paint trading. The officer did describe that the defendant's car moved forward and then moved backwards. Moving forward was the car in the garage that was hit. And he failed to stop after that collision, instead driving away until he was stopped by the officer. Once he got into the roadway, but before the officer showing up, would have driven away. And by driving and backing away and getting into the street, I'm going to argue that he did drive away after that collision. Now, for failure to stop after a collision, it doesn't have to be at a highway. It can be in a personal place or a residence. So we're alleging that the collision happened in the driveway, in the garage. That jerk motion was him hitting the car, realizing that he wasn't driving. He then backed out and took off. But before the officer showed up, he would have been. Now, we also stipulated to the license plate that was on his vehicle, that he did display on his, whatever the vehicle type, but
Equinox.
the was belonging to a Ford F-150. That is the license plate registration title. It was a license plate not made or not for his vehicle that was fixed to his. Therefore, I think you have mind over on those 2 additional.
Thank you, Judge. With respect to count 1, there has been no credible evidence of strangulation, Judge. This officer indicated that shortly after this incident, she prepared a domestic violence incident report where she's supposed to document injuries that she sees, signs of strangulation. Strangulation is so common, Judge, that we make it part of the name of the GBH statute. Officers are trained to recognize those signs, certainly to take a narrative, which she did, but to recognize those signs. She states very clearly, she made no notations as to injuries observed at all on the body. If someone's being strangled for 15 seconds at a 10, Judge, there's gonna be bruising at a minimum. We didn't hear any indications that there was loss of consciousness, difficulty breathing that she observed, and she arrives 30 seconds after this is supposed to have happened. So it's not just shortly after, it's basically immediately after. To see no injuries, to not notate that there's any indication of strangulation, there is not even at the probable cause level enough for strangulation. Her narrative will maintain our objection as hearsay. But with respect to count 2, which is domestic violence, Judge, if Your Honor chooses to credit the narrative of this officer, sure, there's enough for domestic violence. I mean, I'm not going to make a useless argument, but I think really the misdemeanor counts are what remain here, Judge. If there's strangulation, there will be signs, and this officer, I think, is obligated to notate those if there is some sign of that. And Jennifer's not here to give her side of the story, which I think should also be considered with respect to the reliability of that narrative. There were at least some attempts for a subpoena. She's not here. I won't speak out of the record as to other subpoena attempts, but for this case, she was subpoenaed. And you know, they have to show some proof of strangulation. And if it's not through Jennifer being here to say what injury she had, it would have to be through this officer observing something. And there isn't that. So for that reason, Judge, we're asking that count 1 be dismissed. Give Your Honor credit to our hearsay objection and ask that count 2 be dismissed. Otherwise, I think the rest is misdemeanors and would be settled here.
Thank you, Ms. Velicky.
Mr. Honor, so I think it's important also that most of the verses don't show up immediately, and they don't, multiple blues differently. I'm sure we've heard multiple testimonies throughout our years doing entirety that everyone was, so I don't think we can consider that. Also, there's no requirement by the statute that there has to be sign of proof, there has to be sign of an injury. It just has to be that the mode was done by strangulation or suffocation, and that being assault. And we heard testimony that it was sort of about 15 seconds, and it was, she had a heart attack. Your Honor, I think we might have been by the word.
I agree. It's a probable cause hearing. I think the officer's testimony about what she was told at the scene by the alleged victim is enough to bind it over. So I will bind over on count 1. And as we've all said, everything else just tags along. AOI date's going to be the 30th, 9 a.m. Anything as to bond, gentlemen, or should it stay the same?
Well, I guess.
Bond will be continued, and Mr. Mullis, good luck downtown. Oh, Mr. Mullis, just to let you know, I know you're not in a position to do it right now, but you owe us $1,000 plus on various things. We're gonna need some kind of payment plan at some point. And I just, I didn't do the statute, I just made it. Yeah.
Thank you, Judge. Thank you, Madam.
Hey, Mohammed. While you're out there, would you tell the attorneys on Lemke I'm ready to go? Thank you. Have a nice day. That's yours, Jacob? Stay safe.
That was nice to meet you. John, Mark did that
What did you?
about saying, I just stipulate, you don't need to.
Oh, yeah, absolutely. Yeah. Yeah, come on up. We can hold? Okay.
Wait, but
Yeah, I'm ready. Go ahead and put your appearances on the People versus Lemke.
Good morning, County Central, 85689. Somebody can stand out and say your name for the judgment.
Thank you. Go ahead.
Your Honor, I
through for competency evaluation. In my conversations with my client, he had told me that he both had injury and traumatic brain injury in the past. And in speaking with him and usually with his daughter also present, it's become clear to me that he cannot recall our conversations, in between.
Yep.
So it's a matter of something that we talked about yesterday or on Friday. Can't remember, and that, the second prong of competency, and in particular, the ability to effectively communicate with counsel and gain one's own defense, I have some pretty, real concerns about that factor. So I would ask that you forward a competency evaluation.
And normally, Your Honor, I wouldn't have an issue with an alternative determinant for.
James Brooks entered court already on probation after damaging property at a hotel. Although the judge learned Brooks had started mental health treatment and was trying to rebuild his life, the warning that followed was unforgettable. The judge placed him on 24 months of probation, ordering him to stay out of trouble, follow his treatment plan, and pay restitution. Then came the powerful message. If Brooks ignored the court's orders or committed another offence, the judge's hands would be tied and harsher punishment would follow. It was a rare moment where compassion met accountability, giving the defendant one final opportunity to change his future.